Welcome everyone, welcome to Mercury Law Review, and today we're going to be starting with the contracts section, and this is the first introductory lecture on contracts law. Alright, so let's start with our contract section, and let's first discuss this word, what exactly a contract is. Okay, so we're studying contract, and let's start by understanding what exactly is a contract. Now, a contract is formed in any transaction in which one or both parties make a legally enforceable promise. I'm going to repeat myself again. A contract is formed in any transaction in which one or both parties make a legally enforceable promise. Now the phrase that is important over here is this. A contract is a legally enforceable promise. Now, what is a promise? A promise is a commitment or undertaking that a given event will or will not occur in the future, and the promise may be expressed or implied from conduct or language and conduct. Okay, so a promise can be expressed or implied from number one, conduct, and number two, language or conduct. So this thing can be from conduct or language and conduct. Okay, now when is a promise legally enforceable? Now there are three situations where a promise is legally enforceable, and hence it will turn into a contract. Now, what are those three situations? Let's take a look at that. The very first one is a promise is legally enforceable where it was made as a part of bargain for valid consideration. A promise is legally enforceable where it was made as part of a bargain for valid consideration. Important words over here: bargain and valid consideration. Okay, so if there is no valid consideration, there cannot be a contract. Second scenario: a promise is legally enforceable where it reasonably induced the promisee to rely on the promise to his detriment. That is the second scenario. The important word over here is reasonably induced promisee to rely on the promise to his detriment. Or now the third scenario over here is is deemed enforceable by a statute despite the lack of consideration. Okay, so I'm just going to write over here statute. Okay, now in the first one, in the first scenario, we said that a promise is legally enforceable where it was made as part of a bargain for a valid consideration. Now, in the third point, we are saying that a promise is legally enforceable where it is deemed enforceable by a statute despite the lack of consideration. So, if the statute deems it to be enforceable as a contract, then it will be enforceable as a contract even though there is no consideration. Okay, now this is important to remember. Now let's move on to the types of contract. Okay, so how many different types of contract do we have? Well, the first type of contract is an express contract. Now, what is an express contract? An express contract is an agreement which is manifested by words. Okay, an express contract is an agreement which is manifested by words. Second type of contract is implied in fact contract. Implied in fact. Implied in fact is an agreement which is manifested by conduct. Okay, so manifested by conduct. Now, when we'll be studying the multiple choice questions on contracts and when we'll be practicing the essay questions on contracts, you'll get examples of all these theory which I'm putting out right now. But let's first understand the basics and then we'll be moving forward, right? Now, the third type of contract is implied in law contracts, which are also known as quasi contracts. Okay, so these are also known as quasi contracts. Now, this is not a true contract but an obligation imposed by a court despite the absence of a promise in order to avoid injustice. So this is an obligation imposed by a court despite the absence of a promise in order to avoid injustice. Okay, now obligation only arises if there is a promise, but in case of a quasi contract, obligation is imposed by the courts in order to avoid injustice. Now, when we'll be doing the multiple choice questions, these things will get more clearer to you. Right now, in the next lecture, we'll be studying about the sources of common law, and then we'll be moving forward with our contracts lecture. Now, a couple of tips that I like to give you at this point of time in your studies. The very first thing that you need to remember is always make notes. While you're watching this video, you need to make your own notes. And as soon as a video is complete, you can watch it as many times as you want, but once you are done watching the videos, try to make one single note of the entire video and try to put in the gist of the video in your notes. Alright, so that will be all for this video. I'll meet you in your next lecture on contracts law. Thank you very much.